Hey, everybody, and welcome to Thursday night. My name is John Skiba, and I am a consumer protection attorney and bankruptcy attorney in the state of Arizona. And every Thursday night here on the Consumer Warrior YouTube channel, we talk about all things debt related, how to defend debt collection lawsuits, bankruptcy, all the other horrible things in life. We're starting a little bit earlier tonight. My kids have a dance recital, so I've got to get to that. So we're going to be a little bit shorter than maybe we normally are. But I appreciate you checking in. If this is your first time here, as you've probably seen on my YouTube channel here at Consumer Warrior, we have a bunch of videos on how to defend debt collection lawsuits. I talk about bankruptcy procedure, wage garnishments, debt settlement, all that kind of stuff. And while I am an attorney in the state of Arizona, I cannot offer legal advice. This is just information. We're here to have a discussion on this. If you need legal advice, highly recommend you contact an attorney in your state to go over the specifics of your case. As I said, my website is scrolling across the bottom of the screen. I'm an attorney here in Arizona. So if you are in Arizona, I would be happy to help you. How we do this each week is we go ahead and we put any questions you have there in the comment section or in the chat section, I guess I should say. And then I'll put them up on the screen and I'm happy to talk about them. So one thing that I wanted to talk about, or at least kind of promote before we get started tonight, if you're dealing with abusive debt collectors, if you're looking for information on credit reporting, things like that, one of the best YouTube channels out there is my friend John Watts. John Watts is an attorney in the state of Alabama. This is his YouTube channel. I highly recommend you go over there and subscribe. John does great work, good friend of mine. We talk throughout the year on different cases and strategies, and he's always a big help to me. We do FDCPA litigation here in my office for people in Arizona, but if you're looking for more information and just another resource, he also does a lot of debt defense stuff. Go ahead and take a look at that. Go over to John's YouTube channel. You can just put John Watts Attorney, or you can go to the actual website address here, youtube.com/user/John Watts. So, all right, let's see if we have, hey, my man Marcos is here. He's under the weather. He's sick. I hope it's not serious. It's always such a weird time that we're in. Anytime you think you have a cold, it's like I heard someone say, can we have colds anymore? Hopefully it's something that's not too serious and you're back at it soon. So let's go ahead and jump into some of the questions that we have tonight. All right. On average, how long from a lawsuit to summary judgment or trial? I'm hearing 1 to 2 years. This is a good question. This is going to be specific to your particular court. It's going to be your state. And even within states, there are different levels of courts. Like in Arizona, where I practice, the justice court system handles anything under $10,000, where the superior court handles anything over $10,000. I was just today pulling some documents from a court in Nevada for a case that I have. Their district court is anything over $15,000. So there's different jurisdictional limits. As far as how long it takes to get to trial, I'll give you the Arizona example because that's what I know. Justice court has actually rules in the rules of civil procedure. They have a whole different set of rules in the superior court. And they state that the case should either go to judgment or trial within 10 months from the date that the case is filed. Now, I've had justice court cases that are 2 years old and they still haven't gone to trial yet because the parties can agree to continue to extend it on out. But on average, most justice court cases, if it's going to go to trial, it'll happen within 6 to 10 months. You're going to get some kind of trial date. There's some courts like the Santan Justice Court. They set trial date as soon as you file the answer, which is good and bad. But as soon as you file your answer, the court will set it. They probably set it like 8 months out. And then you have a trial date that you're working towards. Now, superior court is a whole other ballgame. It takes forever. Civil cases in superior court, particularly in Maricopa County, which is the Phoenix area, from the day that the lawsuit is filed until it gets to trial is usually minimum 12 months. More likely it's going to be 18 months. And for more complex cases, it can be upwards of 24 months to get to trial. So it can take a long time. That's the trial. Now, your question talks about the summary judgment. I can tell you the summary judgment is going to come a lot quicker. Usually what I see is the junk debt buyers like Midland Funding, Portfolio Recovery, and that they'll file their lawsuit. You file your answer. Usually about 30 days, 40 days if it's a justice court. They'll file something called an initial disclosure where they provide all of their documentation, all their evidence. And often you get hit with a motion for summary judgment soon after that. So that could be 3 to 4 months after the case is filed. They'll hit you with a motion for summary judgment. I see the same thing in Superior Court. And because you got to remember, from the debt buyer's perspective, they want to get this thing over with quickly. They may be handling it on a contingency where they don't get paid unless they get money from you. There's no benefit to them to string it out any longer than they need to be. And so they're going to go ahead and file that motion for summary judgment. So that's my long-winded answer of how long it takes. Generally, you're looking probably in the lower courts 6 to 8 months to trial. The upper courts, it could be a year or more. The summary judgment will come much quicker. So thank you for that question there. All right. Don't have any other questions right now. So if you do have questions, go ahead, put them in the chat section. Otherwise, it'll be a pretty short session, which is not a problem. We can go short today. All right, let's see what Crypto Life. Excuse me. I've been on the phone all day, losing my voice here. Can you still negotiate a settlement after your answer and before trial? Yes. And you may be surprised to know you can negotiate a settlement even if a judgment's been entered against you. A lot of what I do all day long is negotiating judgments that are 5, 6, 10, 20 years old. We'll go in there and negotiate that. So often, particularly you don't want to let a default happen. So if you get served with a lawsuit and you're either trying to negotiate or you don't know what to do as far as negotiation goes, so you just file the answer, that's a good thing. Don't let the default judgment be entered. But then, you can negotiate, often negotiations and happen right up to trial. I had a case earlier this week that went to what's called compulsory arbitration here in Arizona, which is part of the court process. And the opposing attorney and I settled it literally sitting at the table at the arbitration thing right before it started. So that happens quite a bit where these negotiations, sometimes it takes a trial or a court hearing or something to kind of bring everything to a head so that you can negotiate it. And even after, if you lose at trial, go in and try to offer some type of settlement. I always say a judgment does not mean money in their pocket. Now, you don't want to wait until there's like a garnishment or something like that in place. If you wait that long, it's going to be much more difficult to get a good deal on it. But absolutely, you can continue to do that. So, all right, let's see. Do pro se defendants, and pro se is just someone who's representing themselves. Sometimes they're called pro per. I don't know what the difference is. I should at this stage of my legal career. But pro se, pro per, same thing. Do pro se defendants ever call a witness on their behalf in a case against a debt buyer that is suing them? If so, what might be an example of a witness that can be used? Thanks. I can tell you in most of my debt buyer cases, it's very rare that I call any witnesses. I don't even call my own client. The reason is often the debt buyers, they show up to trial and they have very little information, very little documentation. And the witness they have is going to be somebody who works for the debt buyer, not the original creditor. And there's going to be gaps in their testimony. Often junk debt buyers will try to use my client against themselves. They'll try to make, the defendant the star witness in the case against themselves. So usually I don't have witnesses that testify. The times where I could see a witness being helpful would be if there's some kind of defense of like identity theft. If there's something that's kind of a little bit out of the norm, other than just the typical dispute. I mean, you could have a defendant get up there and testify that, something that's kind of obvious, but sometimes courts really latch on to is that, I don't owe any money to Midland Funding, or I didn't enter into any contracts with Midland Funding, that kind of thing. In most cases, though, it's not necessary for a defendant to have witnesses. And again, because you always have to remember the plaintiff bears the burden of proof. It's their case. They have to prove it. You don't have to disprove anything. And so if they can't do it, don't get up there and fill in the gaps for them. So Dave Lamb, thank you each and every week. I appreciate you supporting the channel each and every week. All right. This is a good one from Helena here. Where are the judgments located now that they're not on the credit report? This is something a lot of people don't know. They're not aware of because forever judgments did show up on your credit report. They showed up under the public records section, which is usually where like bankruptcy show up. If you had a judgment, it would say judgment, have the court date, all that. I believe it was the summer of 2017, the credit reporting agencies, Experian, TransUnion, Equifax, they changed their rules and they said, we're not doing this anymore. We're not going to list judgments in the public records section unless there is readily identifiable information that connects the defendant to the person's credit report. Usually what they were saying is that the full social security number would have to be on the front of the judgment. That's not going to happen. And so, in effect, since 2017, we don't see any judgments on the credit reports anymore. So the question is, where are they located? Well, obviously, they're located at the court if someone was going to go check that. But usually where people see them is they are recorded. Most creditors will record the judgment with the county recorder. Now, you can look this up in most states and in most counties. You could just search like I'm in Maricopa County, I look up Maricopa County Recorder. I can plug a person's name in, and often the judgment will come up. The reason why they do that is because a recorded judgment in many counties will act as a lien against real estate that is located within that county. Now, there's some exceptions to that. There's homestead exemptions that can protect your home, that kind of thing. That's generally where you're going to see them, though, is with the county recorder or located in the courthouse. Otherwise, they don't show up. And that's why you see, if you go buy a new car, but you're showing that they pull your credit, even if you have judgments, they're not going to be able to see that. So, all right, let's take a look at what else we have. So scan through here. Let's see. We got a question about LVNV. LVNV attorney asked for a copy of a Social Security benefit statement to see if they would qualify me for a hardship exemption. Is that a trap to basically have you admit that they own the debt? It's a good question, and a good bigger question is if you're negotiating a settlement, sometimes the debt collector, the debt buyer, they're going to want some type of proof of hardship or showing that you can't afford to pay more. Now, there's two reasons that they're doing it. I believe that they do use that to determine if there's true hardship, but they're also creating a file in the event that they get a judgment against you. They know where to go to look for assets. So, like, I never give bank statements. I don't want to give pay stubs. I don't even let people know where my clients work. But the one exception to that is Social Security benefits. Social Security benefits are exempt under federal law, so they can't take those. So not only does, if I have a client who's on Social Security, not only do I say, hey, look, there's minimal income here, but two, there's income that you can't touch. And so if you get a judgment, you're out of luck. You can't garnish it in a bank account. You can't garnish it in their wages. And so in that, I would, if your Social Security number's on it, like if it's the award letter that you received or the cost of living update letter that they put out each year, I would redact your Social Security number if there's any private information on there. But I don't see any harm in providing something like that specifically. I would just be careful with the, for sure, bank statements, pay stubs, stuff like that. You don't want to have to deal with those. So, all right, let's see here if we've got anything else. That might be. Let's see. Let's do this one here. Well, let's do a couple of these. Any idea how long it takes Midland to remove collections from a credit report? Now, if you have negotiated a settlement, you want it to be removed, you need to ask that specifically, negotiate that specifically. Otherwise, there's no requirement that they remove it, and they may not. I've seen that Midland typically will. If you ask them, they'll make that part of the negotiation and they'll remove it. But some of them, they won't do it, and so you need to make sure that you ask. Otherwise, if it's just a regular negative derogatory thing that you haven't settled, 7 months or 7 years and a few months before it's actually going to fall off there. Let's see this one here. What in the case you're retired and protected income and you're sued? You notify them that you're protected. Does the junk debt buyer still go for the judgment? This is really a case-by-case basis. I do see this quite often. Someone will get sued and they're essentially judgment proof is what we call it. That even if they get a judgment against you, there's nothing they can really do to collect. They can't, there's no wages to garnish. The Social Security is exempt, or all the income is exempt. The only other thing you have to look at is if you own real estate, because in some states, a recorded judgment, like I was saying, can act as a lien against your home. And then if you go to refi or sell the home, you're going to end up paying it out plus interest. That could be a huge thing. So sometimes, even though it doesn't look like that they are willing to or they're going to be able to collect on the judgment going forward, they still will go ahead and pursue the judgment. Not only that, like Arizona, they just changed the laws. Civil judgments are good for 10 years, and they can be renewed every 10 years for the rest of your life. A lot of other states are that way as well. And so some of them will get the judgment, just keep recording that or renewing it over and over again, and literally take money out of your estate when you die, kind of thing. I mean, it's gotten crazy. That's changed over the last 10 to 15 years. It didn't used to be that way. Now you hear about the zombie debt, things like that they just don't ever seem to die and they don't go away. So they may still be willing to do it, but likely they are going to be willing to settle for much less. So if the lawsuit is not for that much, then sometimes I would say, you know what, it's probably worth it to enter into some type of low dollar settlement negotiations. All right, Alex, thank you for supporting the channel. Shout out to Yuma, of course, each and every week. After a junk debt buyer loses a motion for summary judgment, do they generally still go to trial or dismiss? In Arizona, they're not going to walk away from it just because they lose summary judgment, because it's important to know if they file a motion for summary judgment and the motion is denied, if you prevail on that, that doesn't mean you win. It just means that they didn't win. And so the case just keeps on going towards trial. It does mean that they should be more likely to discuss settlement or low dollar settlement, because it's already been shown that there's some problems with their case. So I have seen it impact it that way. So, all right, let's talk about this one. Can you explain the difference between adjudicated and a dismissed judgment? Yes. So my guess is where you're getting this is on the Arizona websites. If you look on the docket, it'll say that a case has been adjudicated. That means that it's fully gone through the litigation process. It's either gone to trial, summary judgment. Judgment's been entered either for plaintiff or defendant, but the case is essentially done. Now, if a case is dismissed, you need to look. It'll probably say adjudicated as well, but if a case is dismissed, you need to look to see, was it with prejudice or without prejudice? A judgment dismissed with prejudice, the lawsuit can never be refiled. A judgment without prejudice, they can actually turn around, just refile it pretty quickly. So those are the main differences between that. All right, Mary Lander said, I had a trial recently with portfolio, showed up remotely, and I didn't have an option to ask to dismiss. The judge just rescheduled it. I felt like it was a wasted day completely for me. One thing you can do, and so what it sounds like here, you have a trial, you show up, they didn't. Okay, I see what you're saying here. So if you didn't show up, or if you showed up and they didn't, and the judge didn't give me an opportunity, I would file a written motion to dismiss. Particularly for trial. That's it. If they didn't ask for a continuance, I mean, that's their day to prove their case. If they're not there, if they can't be bothered to show up, the case should be dismissed. I would file a written motion to dismiss on that. Alex asked a good question. Thursday edition, Thanksgiving edition of this. Do we really want to talk about this stuff on Thanksgiving? I'm game for it. I'm going to be up at my folks' house. This would be a Utah version of the Thursday Night Live. I'll think about it. If we're going to do that. We'll see how strong my mom's internet connection is at her house. So, all right. I think that's it. I think that's what we're going to do for today. So I do have to run, but I appreciate it. And I hope, just in case next week we don't do it, I hope you all have a great Thanksgiving, and we will